Good afternoon, everyone. My name is Kenitra Brown, and I am the staff attorney and engagement coordinator at the Deason Criminal Justice Reform Center. And welcome to our monthly series, our CJR Scholarship Workshop Works in Progress series. Typically, as most of you know, if you're a frequent attendee of these events, our director, Professor Pamela Metzger, usually moderates these conversations. Unfortunately, Professor Metzger is unavailable this week due to a very recent family emergency. So I am afraid that I'm stepping in to moderate this conversation on her behalf. I am not nearly as good of a substitute as Pam, but I hope to do both of our guests justice today. As you guys saw in the invitation, this is a very special presentation. We'll be discussing Fourth Amendment scholarship, doctrine, and application. And what makes this presentation so special is that we have two presenters from two different universities who we're hoping that their presentations build on the other. So to accommodate both speakers, we have a slightly longer runtime on this program, and we have a few different rules about how we'll engage with their work. So first, we'll allow our first speaker, Professor Michael Gentithes, to present, and then our second speaker, Professor Eang Ngov, will speak. And only after their presentations will we have the Q&A session, which is usually pretty lively if you've joined us before. We usually don't want for conversations or questions. Another special portion of this presentation is that this is one of our CJR workshops where we've actually actively invited students to join. Professor Gentithis asked if his students could watch and see how workshops work among legal professionals, either academics, practitioners, um, stakeholders, or any other people who are interested. He wanted his students to have a grounding in how these types of conversations work and happen. So we've invited his students to join, and a few of them will be in on the conversation too. As a reminder, when we get started, if you have questions or comments throughout the presentations, you can feel free to throw them in the chat. When it's time for the Q&A, you can feel free to actually speak out loud and ask a question out loud. This is meant to be interactive. It's meant to be conducive to feedback that helps our professors with their research questions or with their direction. And finally, if you have any questions and you don't want to ask them in the chat so that everyone can see, feel free to private message me your question in the chat section. Again, I'm Kenitra Brown. You should see me in the chat function as a host. So with no further ado, we'll get started, and I'll introduce our speakers and I'll let them get started with their presentations. Our first presenter is Professor Michael Gentithes. Michael Gentithes joined the University of Akron Law faculty as an assistant professor in 2019. He was previously a visiting assistant professor at Chicago-Kent College of Law and an adjunct professor at Loyola University Chicago School of Law. Professor Gentithes practiced as an assistant appellate defender in the Office of the State Appellate Defender, where he represented indigent clients in criminal appeals throughout Illinois. Professor Gentithes also has experience as a judicial clerk and associate in private practice. His teaching and research focuses on criminal procedure, constitutional law, legal theory, and legal research and writing. His articles have been published in law reviews across the country, including the Iowa Law Review, Harvard Civil Rights and Civil Liberties Law Review, William and Mary Law Review, Georgia Law Review, Missouri, Tennessee, Washburn, and others. He earned his LLM degree in legal theory from NYU School of Law and his JD from DePaul University School of Law. Our second speaker is Professor Eang Ngov. Professor Eang Ngov received her BA from the University of Florida, magna cum laude, and her JD from the University of California at Berkeley School of Law. Before joining Barry University Dwayne Andreas School of Law, Professor Nagov practiced domestically and internationally. She was a deputy prosecuting attorney in the state of Washington and practiced in Germany with the U.S. Department of the Army as a civilian attorney advisor. The U.S. Department of the Army awarded her the Commander's Award for Civilian Service and Performance Awards for her legal service to deploying soldiers and their families during Operation Iraqi Freedom. Her scholarship focuses on constitutional law and constitutional criminal procedure, particularly individual rights and equal protection, and her writing has been published in the Stanford Journal of Civil Rights and Civil Liberties, the Utah Law Review, and American University Law Review, among others. Her articles have been cited by the U.S. Supreme Court amicus briefs, U.S. district courts, and the state Supreme Courts. Prior to joining the Berry faculty, she taught at Florida A&M University School of Law, where she established the prosecution clinic and taught constitutional law 1 and 2 and free speech. Please welcome our presenters.
All right, I will jump in there and thank you so much for the lovely introduction and for inviting me to speak. It's a pleasure to be here and to speak in the company of Eang as well. I think this will be an excellent presentation that should feed into some big ideas about constitutional criminal procedure and the Supreme Court's jurisprudence in some crossover areas, specifically on the Fourth Amendment. Thank you to everyone that is attending, especially those of you that are not my students and weren't required to come here. I'm going to go ahead and share a PowerPoint with everyone, and then we'll get started. Okay, so as you saw in the materials I provided before today's session, the piece that I am presenting on focuses on reasonable expectations of privacy, a test that's familiar to most folks who have studied the Fourth Amendment, as my students have. And it makes a somewhat counterintuitive argument that there is value to that reasonable expectations of privacy test, and maybe that's not something we should so quickly dismiss, especially in light of some of the critiques that have come from an originalist perspective of that test in recent years. So to get started, I just want to remind everyone what we're talking about here. The Katz test is the basic understanding that the Supreme Court has of what qualifies as a Fourth Amendment search. Justice Harlan famously announced his understanding of the rule that has emerged from prior decisions in 1967's Katz case, Katz versus United States, in a concurring opinion. According to that view, a search occurs whenever a person has a constitutionally protected reasonable expectation of privacy in the place or information that the government examines. And that understanding was subsequently, over a series of decisions in the next decade or so, elevated to something that the court now calls the lodestar of its Fourth Amendment jurisprudence. But at the same time, it's not one that has been terribly popular. This is just a small sample of the kind of language that has been carried at the Katz test over the decades by scholars, by justices, by practitioners, really from everywhere. Everyone seems to have a problem of some kind with the results of Katz. And largely this stems from the difficulty in describing an overarching rule, or an overarching justification rather, for that standard of reasonable expectations of privacy, one that would lead to hopefully more determinate and more predictable results. You see here my personal favorite, amorphous nothingness. It just becomes sort of a jumbled mess because so many different courts have to try to take a perspective on what a reasonable person would think. And so the critiques assert you end up with just thousands of different versions of this test rather than one clear overarching view. So those critiques, they come from all sides, from liberal, conservative, and they've started to pick up steam, particularly in the last few years, from an originalist viewpoint. And I'll just turn to some of the language from a monumental decision in criminal procedure a few years ago, Carpenter. Both Justice Thomas and Justice Gorsuch, Justice Alito a bit as well, were very critical of the Katz reasonable expectations of privacy test, and along the same lines that we have heard from scholars critiquing the test over the years. It's just policymaking, not neutral decision-making that anyone could predict in a reasonable way. It's not left to a concrete evaluation that courts are able to perform. Rather, it's just left to the judicial imagination to flesh out this abstract idea of reasonable expectations of privacy. And there have been, in recent years, also some proposals to take these broadly originalist views and make a more determinate Fourth Amendment. I'm going to run through a few of those in a moment, but the idea here is that Katz is just too indeterminate. It doesn't give judges enough guidance. They have to use a ton of discretion to flesh it out on individual cases, while maybe starting from first principles, from an originalist perspective, we might be able to limit discretion and provide a more determinate view on when the government conducts a search and thus when the Fourth Amendment might apply. But let's think about why that is, why we want those kinds of clear rules. And this is a strand that you see often in Supreme Court jurisprudence that I try to represent graphically here. We need these bright line rules for the confused judges that are out there trying to apply this stuff, and for the confused cops that are out there trying to implement it in the field. Originalists aim, at least in part as a broader statement about originalist interpretive theory, to interpret constitutional norms in a way that's going to limit judicial discretion, binding judges to a rule that fits with some conception of original intent behind the constitutional language maybe, or original intended meaning. We'll talk a bit about those theories in a minute. And you see that in the Carpenter opinions that we just reviewed in Gorsuch and Thomas's views, and in earlier property-based jurisprudence of Justice Scalia in cases like Jones and Jardines. This desire for bright lines, though, is not exclusive to those who take an originalist interpretive method. It comes through really across the ideological spectrum, and I trace that a little bit in the paper. As early as 1981's New York versus Belton, you have Justice Stewart claiming that we need clear lines so police can regulate their day-to-day activities. 2001's Atwater versus City of Lago Vista, Justice Soucher claiming that a responsible Fourth Amendment is not well served by standards that require case-by-case determination. Justice Kennedy suggesting the same about 10 years later, and I could go on and really expand that to all fields of Fourth Amendment jurisprudence, that generally justices agree we need bright lines. There's a bit of a shared goal here. So I take the view that if that's the goal that everyone shares, the originalist critique only really takes hold if it does a better job than a judicially created test like Katz of achieving these bright lines and clear, easy rules to implement. But what method really does achieve that desired clarity? And that's where I try to reveal that originalism might secretly generate more indeterminacy than those who are supporting the originalist interpretation seem to give credit for. Now, again, there's three broad camps here when you take an originalist perspective on the Fourth Amendment that have emerged over the last 10, 15 years. The first is a property-based theory, and this began with Justice Scalia in a few cases that involved physical trespass onto someone's property, either attaching a beeper or a tracing device rather to a suspect's car in the Jones case, or invading the curtilage of a home, actually getting on the front porch of someone's home in Jardines. And you see this reflected a little bit in the scholarship as well. Jeffrey Bellin at William & Mary has suggested a Fourth Amendment textualist view that says it has to be your person, house, paper, or effect before someone invades your privacy in a way that amounts to a search. So again, ownership matters in some way. It's got a property-based bent to it. And you see that now more explicitly from Thomas and others in Carpenter. Now, there's positive law theories that have also emerged more recently. And here I'm thinking of Bode and Stern piece about 3 years ago. And what that suggests, and Justice Gorsuch has picked up that strand in Carpenter, is that we can look to some form of the common law, maybe the common law in 1791, maybe current common law. We're not quite sure where it would emerge. But if you just look at positive law, common law, you can achieve some clarity in what amounts to a search. If you violate those principles of law, those positive law ideals, then you as a government actor have committed a search. There is sort of a third blended camp here, and this comes out a little bit in Alito's dissent, where he says that in fact, if you take an originalist perspective, the authors of the Fourth Amendment were to some degree concerned about privacy as part of the original public meaning of the Fourth Amendment. So privacy should still be in the mix somewhere, perhaps mixed with a property-based conception or some reasonableness trickling back into the calculus. So we see already that there is at least a triumvirate of possible originalist theories. So maybe it's not generating as much clarity as we expected. Why would that be? A lot of it has to do with what I call source problems in originalism. First of all, there's many different theories of originalism itself. It's hard to paint that with a broad brush, but I'll run through a few of the larger camps. Sort of the traditional, the maybe original originalism was original intent originalism, where you're hoping to get at some conception of what the authors of a constitutional provision intended. What's emerged more recently, original public meaning originalism, focuses instead on what the publicly understood meaning of those constitutional terms would have been at the time of enactment. And that opens up a wider perspective of possible views. And then another even more recent strand, original methods originalism, which tries to examine how an attorney or a qualified lawyer of the day would have tried to interpret the constitutional text. What interpretive rules would they have deployed? And we should deploy those same rules to understand what it means. Now, all of those are going to look at different sources and weigh them differently. So you inherently have some source issues because there are different versions of originalism as it evolves as a way of interpreting the Constitution. That is an even bigger challenge to overcome in the Fourth Amendment, simply because there is not much originalist source material to work with. We know there are motivations for the Fourth Amendment, writs of assistance cases that really motivated the founders in a lot of ways, but specifically in drafting the Fourth Amendment. There's a few early paradigm examples of searches. I talk about the Wilkes and Entick cases where you have government agents or agents of the Crown breaking into a home, shuffling through private papers. So that's sort of a paradigmatic search. But beyond that, you have to kind of reason inductively from those examples. And those cases aren't carefully litigating the meaning of a search so much as whether a warrant was valid and thus the officers or agents did not trespass and couldn't be subject to private suit. Remember, these are early cases before anything like the exclusionary rule we now have to keep evidence out of a criminal trial if someone violates Fourth Amendment rights. So all that was at issue was really civil liability for those who are doing the possible searching. Now, this isn't to say that there aren't source problems like this in a judge-made rule like reasonable expectations of privacy. You know, whose perspective do we have to look at? What officers think is reasonable, what all citizens think is reasonable, maybe what citizens sharing a particular socioeconomic background or life experience that is similar to the defendants would expect. But surprisingly, courts tend to overcome those and develop over time some fairly clear rules. And that's the second secret that I want to reveal, that maybe Katz is not so much of an amorphous nothingness as it has been ascribed to be. Anyone who's studied criminal procedure over an extended period might get frustrated with the web, the tangle of rules that emerge, but it's not so much that those rules are unclear or hard to nail down. It's just that they are difficult to unify under a grand theory. Think about all the clear guidance that has issued from the court, requiring a warrant based on probable cause to enter a home absent exigent circumstances. We know about rules for searches incident to a valid arrest in a home, in a car, in other public areas. Clear rules about vehicles, when you can execute a traffic stop, even including a misdemeanor. The rules are myriad and they are in fact clear, and they get drilled down upon in even more detail if you look at the lower courts, who begin to deploy some more localized knowledge to what folks might be expecting as private in their daily lives. More recently, I've argued that in the Carpenter case, the court is starting to take a categorical approach to decide how to deal with new technologies when accessing data that's maintained by someone other than the suspect themselves, some third party might amount to a search. Maybe cell site location information over a series of months, which was an issue in Carpenter. That's just a little too creepy to allow officers to warrantlessly access, but we're going to put that category to one side and evaluate each new category of data in a different way. Again, lower courts have done a lot of work here as well. Oren Kerr provides a really helpful catalog of lower court opinions that gives some specific rule-like interpretations to Katz, including rules to guide searching stolen goods, opening screen doors, searching a hotel room after checkout, and so on. So commentators that bristle at Katz might not be frustrated so much with the lack of clarity, but with the lack of overarching theory to explain how all of these rules announced by different courts with different views at different times all fit together. Really, the rules generated under Katz's permissive standard do some work in limiting judicial discretion, both for future judges and for police officers. And that's something that I think gets lost. The commentator's frustration, and maybe even the justice's frustration, is that the rules defy a broader theoretical explanation, not that they are not rules at all. And that gets to what kind of rule really Katz is. It's not a typical rule that's black and white. 55 is the speed limit on the highway here. It is more a standard that gets rulified over time. And here I'm borrowing from Frederick Schauer and Michael Cohen's theory on the rulification of some standards. We've all heard the idea that judges tend to resist hard-edged rules. They'll soften the corners of a hard rule for certain situations where justice seems to require it. The same phenomenon happens in reverse, though. Discretion-granting standards often get hardened and categorized over time by judges that want to allow a little bit less discretion for future actors, to clarify the rules for those who are trying to implement a court's decision. And this gets back to an idea in the psychological literature known as the tyranny of choice. Judges, in fact, don't really love a widespread standard that gives them a million discretionary options. It's the same problem that you have if you walk down the cereal aisle in your local grocery store and you've got 100 different choices. It's not easy to sort through all of that. It takes time and it is cognitively taxing. What we're generally drawn to is a smaller set of options. We try to concretize things. We try to make it a little bit easier to select among a few options or a few concrete rules. And judges do the same thing. They don't love discretion granting standards any more than they love hard-edged rules. So over time, judges tend to rulify standards one case at a time. They create examples of that standard's application to facts. Eventually, more courts kind of glom on to those examples and they become categorical rules. And this happens naturally and sometimes even at the permission of the higher court that has announced the original permissive standard. And that's what I posit Katz might be. It's the kind of standard that the Supreme Court issues in the hopes that this exact thing will happen. Lower courts will take time to fill in the gaps with bright lines. Now, they could say, no, we don't want bright lines ever. This is a mandatory standard that always has to remain somewhat wishy-washy, a totality of the circumstances test say. But that's really not what has happened with Katz. That was never the way it evolved. That's not the way it's been interpreted either. So rulification has already begun in the Fourth Amendment under the Katz standard. The Supreme Court slowly elevated reasonable expectations into this Fourth Amendment lodestar, as I mentioned at the opening, showing that really all along it was a permissive standard. It was kind of descriptive originally in Harlan's version, and lower courts have received it that way as a permissive standard that over time can be concretized, can be rulified, and that's exactly what happens and why we have so many rules in the Fourth Amendment arena. And this is a normatively desirable process, I posit in the paper. Remember, when we're dealing with criminal procedure, the only limit to the new hypotheticals you can spin out is the ingenuity of those committing crimes and those investigating them. So it's fairly likely that any hard-edged rule is going to eventually fall apart when you have new case X, Y, and Z. And the same is true when you're dealing with a standard. New cases will come up that require us to think a little bit differently. Broader theories we derive to handle all of those facts are almost destined at some point to appear incoherent, whether they're originalist or whether they are judge-made. So maybe the best thing that courts can do is work on this kind of categorical basis. Start from a permissive standard that gives us a place to begin when we have a new set of facts. otherwise begin categorizing facts into different bright line rules a little bit further down in the decision-making process, maybe where we can capture some localized knowledge by individual judges. New bespoke facts are always going to require some new bespoke rules, but the process of rulifying a broad standard like reasonable expectations to deal with those new factual developments is a helpful one that judges are already doing and should continue to do. And lower courts can do this effectively. There's some empirical studies out there. Nicholas Kahn-Fogel has a great one on Fourth Amendment cases that suggest the Supreme Court doesn't think lower courts are getting this area of law wrong any more frequently than other areas of constitutional law. Courts are capable of this kind of decision-making. It's a reflection of the common law process that judges are familiar with and have been trained in, and that even my law students in this room have been trained in to understand how rules evolve and change over time. So maybe that's the way this system should work. I posit at the end of the paper that Katz can largely achieve the kind of discretion-limiting rulification that originalists who have critiqued it claim to want, mostly on its own. There might be a place for originalist theories where cases address physical access to property in ways that are roughly analogous to some of those lodestar early cases where you're shuffling around in someone's papers and breaking down someone's door. But let Katz take the leading role in a lot of other cases that involve new approaches, new technologies, so we can start to work on that categorical basis and concretize the meaning of the Fourth Amendment a little bit at a time, the way courts have always done this in the past. So that's where I kind of end in the paper. I suggest this fits in with a policy model of the Fourth Amendment, where you're thinking about the consequences of leaving police conduct unregulated and whether that's really a problem in our current conception of civil liberties. But I'll kind of leave it at that because I promised to try to keep this under 20 minutes and I see I'm pretty close to that, if not over. I always end these kind of presentations with a little bit of fear and self-loathing to stimulate some discussion amongst the group. So here's some questions that I posit to you all, whether I'm giving an appropriate discussion of common originalist theories and giving them fair shake, and analyzing their source issues when they're focused on the Fourth Amendment specifically, and whether I also make a fair conception of what Katz's role can be, whether I should oversell that or undersell that a little bit more. With that, I will stop and turn things over to my co-presenter. I really look forward to your questions from everyone. Feel free to speak up. I'm always happy to try to refine my thinking in this area and make the paper sharper as we go.
Thank you. It's a lot of coordination. I'm not sure that I can rub my head and chew gum at the same time. Michael, I enjoyed your talk, and I want to begin by thanking SMU and the Center for this opportunity, as well as Professor Metzger and Kenitra Brown for her coordination and her efforts. I really appreciate also, Michael, giving me the opportunity by you sharing your time, so I appreciate it. My talk is about the third-party doctrine, more of a concrete application of Mike's talk there. And my thesis is about recognizing the dichotomous relationships in the Fourth Amendment third-party doctrine. So with the third-party doctrine, we know that the conception of the expectation of privacy changes when we give information to other parties, whether they be persons or businesses. The court says that our expectation of privacy is diminished when we share that information with others. We voluntarily expose ourselves and the information. Therefore, we have to deal with the consequences of any misplaced trust. So today I'll briefly talk about the development of the third-party doctrine and talk about some cases that invite us to change the course of the third-party doctrine. And then I'll reveal my thesis, which is that we should go back to the original set of cases that animated the third-party doctrine, those being the false friends cases involving personal relationships, not business relationships, as Miller and Smith applied the third-party doctrine to. And then I'll talk about the problems with current third-party doctrine and provide some benefits for reconceptualizing the doctrine to eliminate the application to businesses and commercial relationships. So the false friends cases are a series of cases with a common thread in that the disclosure was made to either a confidential informant, a snitch, or an undercover cop. And these cases are similar in that they're central to the theme of the third party doctrine. They illuminate the doctrine's core, which is privacy and trust, and whether it's reasonable to rely on a third party and whether it's reasonable to trust a third party. So the first case on Lee and the last case White are very similar. In these cases, the court held there's no Fourth Amendment violation because the defendant made incriminating statements to an acquaintance who was then working with cops who was wired and transmitted the conversation. The court in On Lee noted that there was no violation because the defendant made incriminating statements confidentially and indiscreetly to someone, a confidant of shady character. So On Lee opened the door for evidence to be admitted through informers and accessories, accomplices, false friends, and others who would betray you. In Lopez, it was an IRS agent who was investigating a defendant. The defendant made an offer of money for the agent to drop the case. The agent pretended to go along with the scheme, and the agent wore a wire and transmitted his conversation. So it's a no-brainer, and it's unsurprising that the court held there was no Fourth Amendment protection. The defendant knew absolutely he was talking with a government agent. He knew the purpose of the agent's visit. And so there is not a concern with Lopez and the application of what would later on be the third party doctrine. In Hoffa, the defendant, Jimmy Hoffa, the notorious Jimmy Hoffa, was in a trial in which he was the defendant. He confided in a friend that he was going to bribe the jurors. The friend was then working with the government because the friend was also in another separate criminal case. And so he went over to the other side and reported on Hoffa. Again, it's not a surprise that you're revealing criminal conduct to another would-be criminal. And Lewis, we have an undercover agent who posed as a drug buyer and was invited into the defendant's home for a drug transaction. So as these cases show, it's unreasonable to rely on criminal collaborators, whether they're in fact criminals or whether they're undercover agents pretending to be criminal, to protect one's privacy. So it's unreasonable to rely maybe on an individual because we assume the risk of betrayal and we bear the consequences of making wrong choices and choosing false friends. But the cases take a wrong turn when they apply the false friends cases to business records. In Couch, the defendant's financial records were subpoenaed through the defendant's accountant. And the court held that the records were permissibly released and there was no Fourth Amendment violation because she knew that her accountant was subject to mandatory disclosure and she voluntarily exposed herself to the accountant. Now, Miller and Smith have been cited for the seminal cases establishing the doctrine for the third party doctrine, but they really only build on these false friends cases and Couch as well. In Miller, we know that in this case, the bank was subpoenaed, or several banks were subpoenaed by the government to provide financial records of the defendant. What's interesting to note in this case is that the banks themselves considered the information to be confidential. And despite that, the court trivialized the confidentiality and treated them as mere negotiable instruments, saying that the defendant voluntarily exposed himself by conveying it to the bank and their employees, and that the banks were highly regulated, so there was a lower expectation of privacy. And in Maryland, the court held that the pen register revealing the phone numbers of the defendants dialing were also not protected, again, because he voluntarily conveyed the information to the telephone company and exposed himself to the business, and therefore he assumed the risk. So what these cases show, Miller and Smith particularly, is that the court went wrong in trying to apply the third party doctrine to business records, that it diverged from the original series of cases involving false friends and personal relationships. So my thesis is that we should return back to the false friends line of cases and not apply the third party doctrine to businesses or commercial relationships. And the reasons for this is, one, we have recent cases that signal that we need to change, that they are dealing with the complexities of the third party doctrine in the changing context, and it's unworkable. And next, the reason why we need to go back to the start of false friends is that there's a significant difference in the trust and privacy expectations between friends and businesses. And there's also a significant difference because businesses are supported by law, that there is an expectation of privacy that the law is enforced in business relationships. And with the conflict between the laws that support our expectation of privacy with business relationships and the clash of the third party doctrine, it causes a cognitive dissonance, which then invites a change for us to go back to the concept of false friends. With the cognitive dissonance comes loss of social capital. I'll talk about each of these in detail. So there are three cases that one might not think of as a joint series for the change that I am suggesting. We're very familiar with Carpenter, but there are two other cases that might seem at first blush to not be consistent or not to be relevant to each other, but I posit that they are. And they are all relevant because all these three cases give us a new definition of what is privacy and show us a new way forward to changing our concept of privacy from what was announced in Smith and in Miller. So in these cases, the first one being the United States Department of Justice versus Reporters Committee, it's a case about a FOIA request, the Freedom of Information Act. We have reporters requesting from the FBI its rap sheets on certain individuals because the reporters wanted to connect these individuals to a corrupt congressperson. In this case, the court had to deal with privacy considerations because FOIA had an exemption and does have an exemption for disclosure of information that would constitute an unwarranted invasion of personal privacy. So the court had to evaluate whether the disclosure of the rap sheet would violate personal privacy. It held, in fact, that the rap sheets would violate privacy, and the court did not allow the disclosure. What's interesting in this case is that the rap sheet is a compilation of all the information that had been distributed through public records. So this was publicly available information, and yet the court decided that there was personal privacy in the information in which the FBI had accumulated. The court noted that the privacy stemmed from the extent of the dissemination. It pointed out the fact that the various disparate pieces of information had been passed along and distributed by different parties at different times. And so they had the benefit of what the FBI call the practical obscurity, that even though they were public records known at one time to the public and readily available at one time, and still, if you take the effort to compile the information, there's something significantly different, though, when the FBI conveniently compiles the information in one document. And that aggregation, that compilation becomes then an invasion of privacy. And so this is an interesting theme in which Carpenter picks up, though Carpenter doesn't actually cite this case. The next case in Ferguson involved what the court considered to be an invalid search because the state hospital had disclosed information about non-consensual drug tests for pregnant women. The state hospital was concerned about the women who were coming in for prenatal testing, that they were abusing drugs and it would harm the fetus and the would-be born child. And even after pregnancy, that they were still partaking in drugs and then therefore injuring the child through nursing. So the hospital coordinated with the law enforcement to give the positive drug results to the government officials arrested and were being charged with child abuse through this theory. The court invalidated the search on the theory that it was a non-consensual, warrantless, suspicionless search. What's problematic about Ferguson is that the third-party doctrine should have been central to this case, and yet it was ignored. Even if it were a non-consensual test of the urine, the third-party doctrine in its normal application would have allowed the hospital to have given the test results to law enforcement, or allowed the hospital to give the urine to law enforcement for testing. So this case falls squarely within the third-party doctrine, and yet the court steered away from the issue. The last case, signaling a time for change, is Carpenter. And we know with Carpenter, the CSLI data, as Michael had mentioned, was for a long span of time, 127 days from one carrier and 7 days from another, totaling over 12,000 data location points. The court invalidated it, distinguishing Miller and Smith, saying there's a qualitative difference between CSLI data and bank records and telephone records from Smith and from Miller. The court said it's timestamp data that provides an intimate window into a person's life, revealing not only the movements, but the person's familial, political, professional, religious, and sexual association. And the court was concerned about the retrospective quality that the data provided to the police that would otherwise be unknowable. So although the court tried to distinguish Miller and Smith, I think that it was unpersuasive. That the expectations of privacy that the court was concerned with in Carpenter are indistinguishable from Miller and Smith. The quality of data was present with bank records and phone records of Miller and Smith. Phone conversations, the numbers dialed, and the bank records give a biography of our lives, just as the cell site location data in Carpenter. Moreover, in Smith and in Miller, those defendants were more entitled to a greater expectation of privacy because those individuals had given their information just to a discrete number of people, the banks and the telephone company. Whereas with Carpenter, not only was his information available to the carriers, but his information was available to anyone driving on the road. Through public monitoring, anyone on the public roads would have known where he was going if they wanted to spend the time investigating and following him. Additionally, in Carpenter, because the information was within third parties, those third parties can do whatever they want with the information, meaning they could have sold the information to data brokers, thereby increasing Carpenter's exposure to third parties. And yet the court distinguished Carpenter from Miller and Smith. And the third problem raised by Carpenter is that the court relied on the theory or the concern about the indispensability of the technology used in Carpenter. The court said that in this modern day and age, it's very difficult for us to exist without cell phones, and that the defendant did not voluntarily give his information up. That's not significantly different in Miller or in Smith. We know banks are indispensable, especially in this modern time, and so are telephones. And so the privacy concerns that were raised in the Reporters Committee case, Ferguson, and in Carpenter are the concerns that were raised in Miller and Smith when the court decided to extend the third-party doctrine to business records. And these concerns signal for us a time to rework the third-party doctrine so that the doctrine becomes consistent with the court's new conception of privacy. So what should we do? We should go back to the line of cases of false friends and recognize that there is this dichotomy of relationships between friends and businesses. And the difference lies in the trust and the privacy expectations that we had between friends and businesses. And those differences are that we don't actually have a concern about a poor judgment being used by defendants trusting businesses, like in the case with the false friends, that the defendant in the false friends cases was subject to the Fourth Amendment because he used his bad judgment in trusting these would-be criminals. Also, I'll talk about the legal recourse, the norms, and industry policing and incentives that make businesses different than friends, and the voluntariness of the information being shared, much as Carpenter had highlighted. So first, with the first distinction, we know between friends and businesses, we operate differently. That when we have businesses, there is an availability of recourse. Friendship is trust without recourse. But with businesses, there is reliance on the business, but we can hedge our bets knowing that we have legal recourse. We have legal recourse in the laws of torts and contracts, as I'll talk about later on. There's also the institutional norms that support our reasonable expectation of privacy in businesses. The norms give us a baseline in which we can expect certain behavior from businesses. Also, we have a greater availability of information from businesses, which further support the trust that we give to businesses and the heightened expectation of privacy we have with businesses. We can read ratings, feedbacks, comments about businesses. There's auditing and monitoring by the government and independent entities that then contribute to our trust and our expectation of privacy in businesses. And businesses have an incentive that friends do not have in maintaining a reputation and in building trust, because they can lose customer loyalty and they can lose their business. So in sum, there's a stark distinction between the relationship of friends and commercial entities, and that makes applying the third-party doctrine inappropriate to the commercial entities. Additionally, the way we share is significantly different between friends and businesses. The third-party doctrine is premised on the idea of voluntariness, that we voluntarily expose ourselves to others. That may be the case with friends, but not so with businesses. With friends, there is the equal power. There's not a power differential, so that when we do share, it is voluntary. With businesses, as we know, if you read a contract that has the take it, leave it terms, and you say, I don't want to agree, then you don't get to participate with the business. So the businesses have an unequal bargaining power that makes our sharing involuntary, much like what was discussed in Carpenter. And the involuntariness is a primary reason for why we should not apply the third-party doctrine to businesses. Additionally, the laws enforce our privacy expectation. in common law, statutes, the Constitution, and international law. We have that supported through tort law, through evidence, through contracts. So we have legal designation of fiduciaries, of trustees. We have rules of evidence that prohibit information conveyed during a doctor-patient relationship, attorney-client, clergy-parishioner relationship from being admitted into evidence. In tort law, we have privacy laws protecting the breach of confidentiality. In contract law, we have privacy and trust being regulated through the good faith and fair dealing and through express and implied agreement of confidentiality. So these legal norms support our expectation of privacy with businesses. The government itself supports our expectation of privacy through the statutes that it pass in protecting privacy, and these statutes are numerous. And Congress even recognized the importance of privacy by designating January 28th as National Data Privacy Day. So fundamental is the concept of privacy in our lives. The Constitution protects privacy, our federal and our state constitutions. Through these cases, Griswold, Eisenstadt, Roe v. Wade, and Whalen v. Roe, we have the court announcing that the Constitution protects a right of privacy that predates the Bill of Rights. And in Whalen, the court even recognized the interest of informational privacy. In international law, governments around the country recognize privacy. In England, there's the Data Protection Act, and in the European Union, there's the General Data Protection Regulation, which is being regarded as one of the strongest and most comprehensive regulation of collection of personal data. So around the world, in the US, through our common law, through our Constitution, through our statutes, privacy is protected, and it reinforces our expectation that that privacy be protected throughout and not fall to the wayside when the third-party doctrine applies. The problem with third-party doctrine as it applies to commercial entities and commercial relationships is that it causes cognitive dissonance by clashing against the legal norms that I've just mentioned. The third-party doctrine disturbs well-established privacy norms, and it upends people's natural and common sense expectation of privacy, which causes cognitive dissonance. Cognitive dissonance is the psychological state of discomfort that results when we hold two inconsistent thoughts. How the third-party doctrine causes cognitive dissonance is that when a person learns that the third-party doctrine does not protect any information shared with others, it conflicts with the knowledge and the practice of the person actually engaging in sharing of information with friends, colleagues, family members, neighbors, and businesses. So the result is that the individual will avail herself of one or two results or other coping mechanism. The individual might change her behavior by limiting what she shares. She may begin to cloister herself, or she might begin to distrust the law, to lose any trust in the law because it doesn't make sense. The loss of trust in the law leads an individual to lose buy-in in the criminal justice system. And this is a concern that is supported by research. Research shows that individuals buy into the law when they believe that the results in the process are fair. When an individual confronts third-party doctrine, although the person's been told through statute, common law, and our Constitution that we have an expectation of privacy, that person begins to feel that the criminal justice system is unfair because now it runs counter to what our laws signal as an expectation of privacy. cognitive dissonance then leads to a loss of social capital. The social capital is built on trust, and cognitive dissonance threatens to undermine the trust and impede a person's social, emotional, and economic growth. The knowledge that the government can access our information restricts the amount of information shared. So it withdraws trust, which then impacts social capital because social capital emanates from trust. Trust is necessary for collaboration. If we don't have it, companies fail and societies falter and collapse. When trust diminishes, social capital diminishes. Social capital is the value that we gain from social networks, from groupings, from interactions, the ability to achieve things that individuals could not do on their own. And it complements economic growth and organizations in society. So in sum, reconceptualizing the third party doctrine to recognize the dichotomous relationship, the difference between friends and businesses, produce many benefits, three of which I'll briefly mention. First, clarity. Mike in his conversation had talked about the importance of clarity to judges and to law enforcement. Oren Kerr had lauded the third party doctrine for its clarity, giving ex ante clarity. My proposal would give similar clarity to say that it just simply does not apply when it involves business transactions, commercial relationships, that it doesn't comport then with our expectation of privacy. So re-envisioning the concept of the third party doctrine then aligns with our natural inclination of what privacy means and with what the law has signaled as expectations in other areas of law. And in the end, it protects privacy and increases social capital. So thank you so much for your time. I welcome your thoughts.
Thank you both so much for your presentations. We're now going to open the floor to any feedback, any questions, and I'd like to remind everyone this is interactive. So our guest, Michael and Eang, may also ask you guys questions about the direction of their research to get opinions from those of you in the audience. So I want to make sure that everyone who's been here or who's new here, that you know that this is a collaboration for feedback. So that's absolutely welcome. Let's open the floor.
Sure. Yeah, I can go. So first off, thanks for the presentations. I really enjoyed them. All right. So Mike, I had a question for you. So I like the idea. I like the direction of the paper. One sort of thought I had is just that clarity isn't everything. I don't know about putting all your eggs in the clarity basket. I mean, I understand that's sort of an assumption that you're working with here, and that's fine. But for certain versions of originalism, which haven't really been fleshed out super clearly, I would think that there is a lot of clarity. Like, for instance, Justice Thomas's approach to Fourth Amendment, like privacy, to the extent that he has one, strikes me as very clear. It's just sort of like you get no protection. There's no exclusionary rule, so it doesn't matter. And searches are just, I don't know that he's done this, but you could just say, look, searches are just, traditional searches, kind of a thing, like the kind that we had at common law. And so nothing is really covered that way either. And that's extremely clear and also extremely, certainly very originalist. But we don't sort of take it on for whatever reason. And I don't know what the upshot of that is, besides that I don't think that applies to Jeff Bellin's article, which is similarly textualist, and I think, is genuinely textualist and genuinely originalist, more textualist maybe than originalist. But Bellin's, especially when you ask Jeff about various things, it gets really fuzzy really fast. And so I don't know to what extent you are going after Jeff in your article, but it might be interesting to really flesh out the ways that Bellin's approach specifically gets really ambiguous really fast. You might, and then you might throw in something about Thomas, or you might not, because I don't know that he's really fleshed his thing out. So what's my question? I mean, I guess my question is, aren't there some versions of originalism that are particularly clear? And if so, why do we reject those? Because they would certainly be excellent on clarity. I mean, I can think of other like bright line rules that would be really clear. Another would be, speaking of the third party doctrine context, that's another one where originalism, including, you know, all sorts of forms of originalism, are going to be quite clear relative to what we have now. Because what we have now is sort of so new post Carpenter, and maybe it'll rulify eventually, but it's going to take years. You know, isn't that an area where originalism might be a thing? And then just finally, no, I'll leave it there.
Thank you, Matt. And you're right. I've passed this on to Jeff Bellin, and we've talked about it in the past, and politely agreed to disagree about whether his theory is clearer or not than some of what I give it credit for. But you're right that it is. I love Jeff's theory because it's so simple to wrap your head around as a general matter. When you get down to the details, that's where you run into a lot of ambiguity. To your original question about Justice Thomas's approach, you know, I guess you're right in that things are crystal clear because of his approach to the exclusionary rule. His approach to the definition of a search, though, I wouldn't give ground to saying that that's exceptionally clear. It's property-based. He picks up a lot of the Scalia mantle, and without really defining how specific we're going to be in following a particular type of property law in a given jurisdiction, maybe, or whether we're going to look towards a broader conception at the time the Fourth Amendment was composed. And even in the cases that have deployed that property-based conception, they focus on trespass-ish kind of activity, things that might not even amount to a technical trespass on a strict reading of property law. Your point, though, is well taken, which is that it's really hard to put everything in the clarity basket. That's not the only goal that we are after here. And I don't think that supporters of a judge-made rule like Katz would suggest that clarity is the only thing that it achieves. It does, however, defy an overarching theory that I can point to right away and say that is a better normative goal than clarity. You know, I think clarity is one of the things it does well. I think it can adapt to new circumstances, or at least give courts the chance to adapt as new technologies emerge. And maybe that'll go well, and maybe it'll turn into a mess. You know, we're gonna have to see how Carpenter plays out in years and decades to come. So I take your point that clarity is not the end all be all. And I need to wrestle a little bit more with exactly what I want the normative catch to be, if not just clarity.
Yeah, and just I'm satisfied with that in the sense that I think you're right that Thomas is sort of unclear because he doesn't really get into what a search is. He hasn't really thought that out. He knows what a search isn't, right? He knows that Carpenter stuff isn't a search, but it's not. Yeah, I guess that's the lack of clarity there, is he's never had to articulate what exactly a search is. And I agree with you that the Scalia approach is far from obvious. Yeah, thanks.
Hi, I'm Mike Mannheimer from Salmon P. Chase College of Law, Northern Kentucky University. So I have one comment / question for each of you. For Eang, I would suggest that the dichotomy is not really between friends and businesses, but between legal obligations and moral obligations. You use the legal norms as one justification being your dichotomy, but to me that seems to be the whole ballgame. Whether you have a legal obligation, whether it's a fiduciary duty or a contractual duty to keep something private. And so let me give you a hypothetical that you can think about while I'm asking my question to Michael. Let's say the police get to my wife and convince her to turn against me. I, being none the wiser, I disclose some pretty damning information to her in the privacy of our home, in the privacy of our bedroom, let's say. She goes to the police. Have the police committed an unlawful, or I guess, have they committed a search at all is the question. There I've exercised bad judgment by marrying this person, or at least by disclosing information to her, in the same way that I might exercise bad judgment by choosing my friends. It's a voluntary disclosure, and it's a voluntary relationship. I would suggest that the difference between the wife and the friends is the legal she has to keep information private. So I'll let you think about that while I ask Michael a question, which is, it kind of follows on what Matt was saying about how clarity is not the only thing. I think there's also, I guess this is two separate comments. There's legitimacy, which you don't go into much in your paper. So why is Katz any more legitimate than an originalist approach? And I guess maybe another consideration is whether not just whether we can make rules. You do a good job of saying the lower courts have come up with rules. The Supreme Court has come up with rules. The lower courts have been faithful in making rules, but whether those rules are good, rules make sense to us. And I would suggest that, if you go up to the average person and say, which of these things is the most important for you to keep private? I'll give you 4 things. Stuff that you throw away in the garbage, intimate conversations you have with a good friend, your bank account statements, or the amount of heat coming from your home. I think the average person would say, well, those top 3 are really pretty important to me. The last one, who cares? And the law is exactly the opposite. The law says those first 3, no expectation of privacy. That last one, the heat coming from your home, yeah. So that's my comment.
Michael, thank you so much for your question. You broke up as you were asking about the husband and wife, and you were, I'm sorry, I missed the last bit. You froze. So you were saying that when the cops come to the husband and wife, and you were positing that it was which obligation?
I'm not sure which part got cut off, but the point is that the wife would have that there is a legal privilege, an evidentiary privilege covering that conversation. So we have a legal norm, a legal rule that says that, I know that that's privileged. I know that she is not supposed to be telling other people this. She might, but there's some legal norm in a lot of evidence that says she at least can't testify about this. So I'm wondering whether you can, and I'm not sure whether that should be considered a search, but I think it's certainly a better case for a search than the false friend.
So in my paper, I talk about sort of the gray area. What happens when you have a friend and then the friend discloses information that it's sort of a quasi commercial relationship? And I think I would apply that application to the wife husband. And my rule that I would apply is that if there is some legal recourse that you could avail yourself of, then you have an expectation of privacy in the information that was disclosed, because the law reinforces that expectation. And so it's easier to say businesses and persons because there are more legal norms applied on businesses, but there is the possibility that there could be legal norms applied to persons. And when those legal norms apply, then I think that you earned that expectation of privacy, and that therefore, it becomes a different relationship. And it's not about bad choice anymore. It's a choice that the law enforces and that the law confirms was a right choice, that we should be able to trust our spouse. right? Otherwise, we wouldn't have marriages. It would be not harmonious. And so in that way, I would address your question in the gray areas when persons might have some protection in personal relationships, as going back to just the legal protections. What gives us our sense of privacy are the legal norms. Thank you so much for your question.
Thank you as well, Michael. So you're right that clarity doesn't itself lend legitimacy to a judge-made test like Katz. And that is part of the originalist goal as well. I think my response would be that when you're dealing with an area of at least open-ended constitutional language, things like reasonable search and seizure, that this kind of interpretation over time that refines and categorizes and rulifies, that borrows from a history of common law style adjudication, I think that in itself has legal legitimacy as a process-based approach to take to those difficult questions. Now, whether that's enough to overcome the objections to Katz that you highlight, which are exactly right on. I see Professor Slobogan is here as well. He's done the empirical work to answer exactly the question that you posed, which is that the public expectation is nowhere near aligned with what the court has actually produced in applying the Katz test. And so some of that is an unfortunate relic of history, but I still think it's worth taking a Katzian approach to deal with new problems, new technologies, new issues that are sure to arise in the future, because that has some inherent procedural legitimacy, and it has a hope at least of adapting with a little bit of localized knowledge by lower courts as well to the new worlds that we're living in. And I saw, Angelo, you had your hand up there. Sorry, I didn't mean to cut you off.
Oh, no problem at all. First off, Kenitra, thank you so much. In the Deason Center, Michael and Eang. So my name's Angelo Suggs Jr., way down the road looking to apply to law schools about fall 2022 to join a fall 2023 1L class, SMU, and many others on that list. Going back to the question, so for Michael, my question would be, you mentioned that the rules over time could become more localized, putting a greater level of trust in the local courts in establishing those standards. Would you say that potentially contrasts with the point of clarity insofar as if standards become more localized, then we get away from a more universal standard to where everybody is operating on those same clear terms? So that's one point of thought or question. And for Eang, one question regarding that trust dichotomy with friends and businesses. It seems that the dichotomy is even more so between trust and information. And this has been touched upon by you both in terms of so in businesses, could one argue that we trust businesses less, which is why we need all the regulations. We need all of the different sources of accountability. We need the Yelp reviews, so to speak, versus if I have a friend, the courts could be somewhat unfair, because if I have a friend, I don't have a Better Business Bureau to research that friend. I don't have a Yelp review. I don't have universal standards by international governing bodies like the EU to in place standards on our personal friendship between that specific friend and I. So could one actually argue, based on that trust standard, that businesses have a history of being trusted less? And then does that kind of go back to where Michael's original point, to where maybe there's too much of an onus that's placed on the friendship and the mutual trust between friends, where the courts don't give enough credit to the fact we don't have full information regarding friendships? So thank you both.
So I'll jump in first for the shorter question with a fairly short response. And you're absolutely right that if we end up with a disparate set of rules in different jurisdictions, that's not adding any clarity to Fourth Amendment jurisprudence over time. But I do think there's still a role for course correction by higher appellate courts and eventually by the US Supreme Court when things get too far out of whack. I think the idea is similar to the state laboratories approach of trying new angles, seeing what works best at local levels. Eventually that starts to catch up at higher levels and eventually all the way up to a uniform nationalized standard, hopefully, or rule rather, I should say, hopefully at the Supreme Court level. But I'll step aside because I thought your question to Eang was really excellent, and I might have a follow-up as well.
Angelo, thank you so much for that thoughtful question, and I'm pondering it. I'm thinking, I think it's a great point that you made, and it makes me think about those movies where people just shake their hands and say, no, we don't need to put it in writing. We can just trust each other as persons and not have to resort to contract. And so, have I gotten it wrong? Is it, which comes first? Is it the trust, the lack of trust, and then therefore laws resulting from that, as you suggest, Angelo, versus my theory of that the trust emanates from the laws there. I would say that the businesses, if you put your trust in a business, you can do something about it when that trust is betrayed. So I might even add, does the law value the betrayals by businesses more, or does the law feel that to be a greater harm than the harm that comes from a betrayal of friends? And maybe that's why we don't have the laws, right? That what's the harm? You've lost your friendship. Oh, you're never going to tell that secret again. What can the court do about it? And so is it that businesses are less trustworthy, or is it that the relationship is more deserving of protection because of the utilitarian value that we then derive from the business relationship, in that it makes the world go round? I mean, friendships make the world go round as well. But right, without businesses, we as a community can't prosper, or as a country. And so the government needs to protect that trust relationship. And so maybe I like your question, and I'm wondering if the other question is also maybe business relationships are protected more because there's more concrete economic harm that can result from the lack of trust that happens when there's betrayal by a business. So thank you. I'll continue to ponder it. I appreciate that question.
And thank you both.
Megan, I see your hand up.
Yes. Hi, I'm actually one of Professor Gentithis' students in attendance today. And my first question is for Professor Eang. What's to stop people from claiming that in telling a friend a secret is actually a business relationship such that it's mutually beneficial exchange? And thus that privacy expectation should be extended to that.
Thanks for your question, Megan. So my thesis, it isn't to say that we should ignore friendships, but more to say that if we begin to reform, at the very first place, we should consider taking out businesses from the third party doctrine. I myself don't like the third party doctrine. I think all of it should be protected. But then it raises the question of when people report to the cops. And I started this paper going sort of wholesale reform of the third party doctrine. And in having conversations with others, particularly cops actually, in which it was raised, well, what do we do when someone wants to share the information with us, with the person? So I've refined my theory to at least begin with the businesses. But as to your question, Megan, my solution is that if a person can make a legal claim before the court, I think that person deserves protection, because my argument is that the law protects our expectation of privacy. And so if there are laws that recognize the claim that can be made, then I think the government definitely should not be able to apply the third party doctrine. So trust is without recourse, without any legal recourse, without any external constraint. And so if in that relationship, whether it starts out as being friends and evolves into something that is more business transaction, quasi-friend, quasi-business, I'm in favor of greater protection and construing at least that interaction in which the information is exposed as one that is deserving of privacy protections because there's legal recourse recognized by the court. So I would leave it up to the courts. If it's something that the court could recognize as protected, then it should be out of bounds. No application of the third party doctrine there. So thank you so much, Megan.
Yes, thank you for that. Actually helped me understand it a little better. And then for Professor Gentithis, my question goes towards the two-part test in Katz. What would you do or recommend in a situation where a private reasonable expectation of privacy doesn't match that of what society views as an expectation of privacy?
Well, you're exactly right that there are two components to the Katz test, but you really, as a claimant of Fourth Amendment rights, need to demonstrate both, that you've subjectively expected privacy and that society agrees that that expectation is a reasonable one. It tends to end up distilling down to just one inquiry because it's fairly simple for a criminal defendant to say, of course, I subjectively expected privacy in that closet where I was storing all of my cocaine. That's where I expect things to be kept personal and private. But you know, I think maybe you're thinking about the disjunction that might be in the other direction, where perhaps you have society expecting privacy in an area where really a citizen or an individual doesn't. And that doesn't end up getting litigated very far because, again, you failed the first prong of the Katz test if you're that individual claimant of Fourth Amendment rights. So, you know, there could be dissonance there, but at the end of the day, courts end up distilling Katz into functionally one step of whether reasonable expectations that society would recognize existed in this case.
Okay. We have one more question, from Professor Slobogan. I'm going to let him ask his question, and he'll be the last question and we can start to wrap up.
Okay, thanks. I didn't get on until 20 minutes ago because I was getting vaccinated. I registered for this, but then I had to cancel. But it turns out I got back in time to at least hear the last part of this. So, Eang, did you have a paper?
Thank you. No, it's I'm finishing it up, wrapping it.
Okay. Well, I just want to make sure there was something I was supposed to read and that I didn't. So this distinction between person and business, I think is very interesting. It's something that I've worked with as well. And I think one thing you could think about, and maybe you are already, is this notion that actually was developed by Rosemary Coombs years ago, that individuals have an autonomy interest in revealing what they know, and they should be allowed to exercise an autonomy interest. And in fact, it trumps, she argues, the privacy interest that the first party might have. And that autonomy interest arguably doesn't exist with businesses. They're impersonal entities. They don't have the same kind of constitutionally recognized autonomy that people do. So if you want further elaboration, I know we're running out of time. So if you want further elaboration of that, I talk about it in my book, Privacy at Risk. And I got the same kind of comment, Michael, on your paper. As you know, I'm a big fan of privacy as the central interest protected by the Fourth Amendment. And I think one thing you could do to help with your struggle over whether clarity is your main major point is to not make clarity your main major point and make the positive case for privacy. And I think there's several arguments in favor of privacy as the central value, not just negative arguments. Well, we can be at least as clear as originalists can be. There are several advantages to making privacy the central value. And all I'm going to do here is, I know this sounds very self-promoting, but what the hell, I've been writing about this for a long time. So on the self-promote, I've got an article in Texas Tech Law Review that argues that privacy should be the central value protected by the Fourth Amendment and gives 5 positive reasons for why, including that we can actually make it concrete and it's scalable. In answer to Michael's question, privacy is something that varies from situation to situation. And so if thermal information is not very private, then it shouldn't get as much protection. It shouldn't mean it's not protected. Whereas other kinds of things are more protected. You can't do that with interests like property or dignity. They're not scalable in the way privacy is. So that's just one example, and I'm stopping there.
Thank you so much for joining us and for your question. And I've certainly read a lot of your work and relied on it in my paper that's a work in progress. So I recognize autonomy as an interest, and in my paper, I actually talk about how we define privacy, and autonomy is one way, and it's recognized in the cases that I talked about previously. I don't think that that changes. We're still respecting the individual's autonomy, even more so because we're respecting that individual's autonomy to engage with businesses and to maintain that person's privacy. So it's not a matter of looking at the business and whether the business has any autonomy. It's about how the information got to the business through the autonomous exercise of the individual, the person's decision to disseminate or withhold information. And so I think it does respect autonomy that way, because we now protect their ability if they want to share, even with businesses. So the autonomy I focus on is on the individual whose information that is then shared with businesses.
Yeah, I'm talking about the autonomy of the person with whom the information is shared. That's what I was focusing on. Now, in Michael's example, the wife, she has an autonomy interest. She should be able to do whatever she wants with the information. The business does not have that.
Oh, I see what you're saying.
Yeah.
Right. Thank you.
And I'll just respond quickly because I see we're just about out of time, but thank you so much. And I don't fault you at all for the self-plug. I'll definitely have a look at the Texas Tech article, but that's a really interesting point, because you're sensing where I came at this project from. It was very negative. It was a response to originalist views that I didn't like. And I wanted to begin with, well, the things you're even trying to achieve, we can do just as well with theories we have now without as much of the positive case. And I think your point about privacy being scalable in a way that property rights or positive law might not be is an important one. And it gets to the overall sense of why reasonable expectations still can do some work here. And that's just a greater flexibility that can be adapted to newer cases, newer scenarios, newer technologies in a way that applying a positive law conception or a property law conception or borrowing from other areas of law that weren't designed in any way to protect privacy or the sorts of things that we were interested in when we started the Fourth Amendment in the first place just can't achieve. So thank you. I think that could be a good contribution to the piece.
Thank you, everyone, for your comments and your questions. It's definitely a huge contribution to my paper. I appreciate your time.
Thank you all for taking time out of your afternoon to join us for our CJR workshop series. I want to send a special thanks to Professor Gentithis and Professor Nagov. I appreciate you both for taking the time to create your presentations, to work with me in coordinating in the background. I really appreciate your patience with us as we've transitioned to this style of workshopping, which actually tends to work. And I thank you for your patience and your forgiveness for Pam's emergency. Again, I know I'm not a great substitute for Pam, but I hope we did justice. And I appreciate you all for your comments. So once again, thank you all so much for your comments, for your attention, for engaging with this incredible topic. And thank you, Michael and Eang, for being so amenable to this type of presentation style. We really appreciate it.
Thank you.
Thank you,
much.
everyone.
Thanks for having us. Bye, everyone. Take care. Stay safe.
Take care, everyone.